how they fabricate Indian citizens, particularly Indian Muslims, in false cases, how they torture the pupils for extracting the confessional statements. What are the observations and directions of the Bombay High Court? What is the finding of Bombay High Court? I will express all this thing before you. I will briefly tell you about the 7/11 bomb blast case. You have heard about it. 11 July 2006, there were 7 bomb blasts in Mumbai local train. Within the span of 6 minutes, 6 मिनट के अंदर 7 बम ब्लास्ट होते हैं. 200 people died, 700 people injured. और उस ब्लास्ट के बाद ATS एंटी टेररिज्म स्क्वाड arrested 13 Muslim youths throughout the India, including me. And after the thorough investigation, they filed charge sheet before the Sessions Court consisting 20,000 pages. 20,000 pages का चार्ज शीट कोर्ट में आता है और उसमें बेसिकली 3 तरह का एविडेंस वो प्रोड्यूस करते हैं. फर्स्ट, द आई विटनेसेस, प्राइम विटनेसेस. सेकेंड, द कन्फेशनल स्टेटमेंट्स. एंड द थर्ड, रिकवरीज ऑफ various arms and ammunition from the houses of the arrested persons. So these 3 types of category of evidences produced before the session court. And I tell you, ये तीनों का तीनों जो एविडेंस है ये फैब्रिकेटेड है, ये प्लांटेड है, ये पूरा पुलिस ने खड़ा है, बनाया है. कैसे बनाया है? हाई कोर्ट ने भी उसको कंफर्म कर दिया है और 655 पेजेस का जजमेंट है हाई कोर्ट का. आई मस्ट से, एंड आई रिक्वेस्ट ऑल ऑफ यू, प्लीज गो थ्रू द जजमेंट, प्लीज रीड द जजमेंट. एंड द सेकेंड थिंग, द लॉन्गेस्ट पेंडिंग अपील इन द बॉम्बे हाई कोर्ट, 10 years pending in Bombay High Court. The Sessions Court delivered its judgment in 2015. From the day of 2015 to 2025, 10 years, this appeal was pending before the Bombay High Court. Third, the longest running appeal in the Bombay High Court. Regularly, 6 months daily, the appeal heard by the divisional bench of Bombay High Court. 6 months daily, from morning to evening. And how many papers? Before the Bombay High Court, 169 volumes consisting of 45,000 pages. And in that 45,000 pages, not a single page is original. I say you, not a single page. Prosecution argued before the Bombay High Court on different issues. Total 80 points raised by the prosecution, 80. But none of the argument, none of the points claimed by the prosecution admitted by the High Court. All were discarded. कोई बात हाई कोर्ट ने उनकी मानी ही नहीं. And you know, the Sessions Court are under tremendous pressure. Public pressure, media pressure, and government pressure. And usually they become rubber stamp of the government. That's why Sessions Court ने 12 लोगों को कन्विक्शन दिया. 5th of them on death row और 7th of them on life imprisonment. Since 19 years they were inside the jail. They were arrested in July, in September 2006, till July 2025 they were inside the jail. No parole, no furlough, no bail, never. They were continuously, for long 19 years, they were inside the jail, in under cell, in Phansi Yard, continuously. You can imagine the mental condition, mental status of that under trial prisoners or that innocent prisoners. There are so many allegations by the ATS on us. The first allegations are they all are SIMI members, Student Islamic Movement of India, which were banned in 2001 in India. And after the banning of SIMI, so many youths were arrested by the police, put inside the jail. And what was the reason? The reason is to extend the bans on SIMI regularly, periodically. And the second allegation is these guys are members of Lashkar-e-Taiyiba and ISI. And they went to the Pakistan via Iran, took the arms and ammunition training and back. They acquired the RDX from the Pakistan. They prepared the bomb in Mumbai and they planted the bomb in first class gents compartment of local train in evening time. Some Pakistani persons came in Mumbai. They sheltered them. With the help of those Pakistani guys, they prepared the bomb and they planted the bomb. These are the basic allegations leveled by the ATS on these accused persons. Now, one important thing, see the community, Muslim community of Bombay and Muslim lawyers of the Bombay, their courage, their himmat. You know, the Advocate Shahid Azmi was our defense lawyer. And the same lawyer was the defense lawyer in 2611 case, in Ajmal Kasab case. What happened? धमकी मिलती है जान से मारने की. And he went to the court for protection, for police protection. He approached the police commissioner for keeping a revolver for his own protection. No reply he received, and ultimately, after some days of receiving life threat, two persons went inside the office of Shahid Azmi and killed him. But after that, ऐसा नहीं हुआ कि वकील हमारा केस लड़ने के लिए तैयार नहीं थे. डर गए सब वकील. आई नो, आई एग्री. लेकिन उसके बाद भी बहुत से वकील, so many lawyers come forward to help us, come forward to defend us. Advocate Shahid Azim के बाद Advocate Shahid Nadeem, Advocate Abdul Wahab Khan, Advocate Sharif Sheikh, Advocate Prakash Shetty, Advocate Yug Mohit Chaudhary, Advocate Nitya Ramakrishna, Advocate ex-judge Justice Muralidhar, ex-judge Justice Nagamuthu. These all lawyers and senior lawyers came forward and defended us. So this is very hopeful and very good for the Muslim community. In another part of India, you may have heard that many bar association passed resolution that they are not going to help, they are not going to defend any Muslim guys who are arrested in terror cases. But not this is the case in Mumbai. Jamiyat-e-Ulama Hind, an NGO who helped these guys to provide the legal help. जमीयत-ए-उलमा हिंद सारे वकीलों को लेकर आया, पैसा खर्च किया, आज तक हमारी हेल्प कर रही है, एंड दे आर स्टिल रेडी टू फाइट दिस केस बिफोर द सुप्रीम कोर्ट. तो वी आर वेरी थैंकफुल टू द जमीयत-ए-उलमा हिंद. एंड there are so many criminal prosecutions rules in Indian criminal system. The first rule is presumption of innocence. Whenever an accused is arrested, it is to be seems that he is innocent until and unless he get guilty. Right to fair trial. लेकिन हमारे केस में क्या हुआ? Presumption of innocence नहीं माना गया. The day one when we were arrested, the media, the police targeted us and labeled us as a big terrorist. The Lashkar-e-Tayyiba man. They are associated with Al-Qaeda, Taliban, Afghanistan, everything. Second rule is right of fair trial. But in this case, no fair trial at the stage of sessions court. Time and again, prosecution not allowed us to file RTI application. Prosecution reply the authority not to provide any information to these guys under the RTI application. They instructed the police superintendent of jail to torture this accused person inside the jail because they are not listening the say of ATS. What were their says? They wanted us to become approval. They wanted us to become witnesses for the government, for the police. We declined because the entire case was and is bogus. The third rule is burden of proof on prosecution. But in terrorism cases, whenever a man arrested, a person arrested, the burden of proof goes on that person. You have to establish that you are not terrorist. You have to establish that you have not committed any crime or committed any terror act. This is very strange rule. In general law, in general sections, it's applicable. But in terror cases, TADA, POTA, MCOC, UAPA, in these cases, ये रूल नहीं चलता है, ये उल्टा हो जाता है. ये बर्डन ऑफ प्रूफ प्रोसिक्यूशन से एक्यूज की तरफ आ जाता है. जस्ट कॉज फॉर पनिशमेंट. आपको पनिशमेंट देना है तो उसके लिए सॉलिड प्रूफ होना चाहिए. और जितना हायर पनिशमेंट है, टेररिज्म के केस में हायर पनिशमेंट डेथ पेनल्टी है, तो जितना हायर पनिशमेंट है उतना प्रूफ का क्वालिटी हायर होना चाहिए. लेकिन उल्टा होता है. टेररिज्म केस में जितना हायर पनिशमेंट है, अगर छोटा सा भी प्रूफ मिलता है, झूठा भी प्रूफ मिलता है, तो यू विल गेट द पनिशमेंट. इन आवर केस ऑल विटनेसेस आर डमी, ऑल विटनेसेस आर फेक, फैब्रिकेटेड. tutor witness, stock witnesses of police. But on the basis of this witness, the Sessions Court given the death penalty for 5 accused persons. Next rule is due process of law. In terrorism cases, रूल को फॉलो नहीं किया जाता. जो ट्रायल होता है उसमें बहुत सारा गड़बड़ी किया जाता है. हमारे केस में हमने चार्ज फ्रेम पर साइन नहीं किया, लेकिन पूरा ट्रायल चल गया. तो ड्यू प्रोसेस ऑफ लॉ को फॉलो नहीं किया जाता. राइट टू अपील. राइट टू अपील में क्या होता है, आपने अगर एक केस के अंदर आपको सजा लग गई है तो आपको हाई कोर्ट, यू हैव टू अप्रोच हाई कोर्ट और सुप्रीम कोर्ट फॉर द अपील. इट्स ओके. बट इन डेथ पेनल्टी केसेस, session judge must approach the high court for the confirmation of the death penalty. It is his duty. And when in September 2015 session judge delivered the judgment and death penalty to five accused persons, the same day he approached the Bombay High Court. And since last 10 years this case was pending before the High Court. So right to appeal means not the long duration of appeal. It means your appeal should be heard as early as possible. Your appeal should be disposed of as early as possible. You know the RTI Act, Right to Information Act. And this is the first Bombay High Court case in which the Bombay High Court mentioned in detail how the accused person used RTI applications, RTI Act, and how they obtain the information for their defense. The first claim of the prosecution is after the arresting, when the accused person put inside the jail, there is a TIP, test identification parade. उसमें ये होता है कि जो आई विटनेसेस होता है उसको जेल बुलाया जाता है और दिखाया जाता है कि यही आदमी है जिसने क्राइम किया है, कि जिसको आपने क्राइम करते हुए देखा है। तो टेस्ट आइडेंटिफिकेशन परेड होता है। और वी वेर इनसाइड द अंडा सेल ऑन दैट डेज। तो अंडा सेल से हमको 2 मिनट के लिए बाहर निकाला गया। अंडा सेल के बाहर मैदान होता है और हमको अंदर डाल दिया गया। और प्रोसिक्यूशन की स्टोरी है, द प्रोसिक्यूशन सेज दैट द टीआईपी टेस्ट आइडेंटिफिकेशन परेड वाज कंडक्टेड inside the Arthur Road, Mumbai Central Jail for 3 hours. But we were taken out from the under cell for 2-3 minutes or maximum 5 minutes. तो हाउ इट इज पॉसिबल 3 घंटे का पूरा जो परेड का एक्सरसाइज है 2-3 मिनट में कैसे पूरा होगा? हम लोग ने बोला, जज ने यकीन नहीं किया। सो वी फाइल्ड द आरटीआई एप्लीकेशन टू द सुपरिटेंडेंट ऑफ आर्थर रोड जेल एंड वी obtained the register of under cell. In every cell of the jail, there has to be a register, movement register, in which the jail authorities, jail havaldar mention the name of the accused persons who are willing to go outside for any purpose and who came back inside the under cell. So they maintain, they write their name, accused name, out time and in time. So we, with the help of RTA application, we obtained all this information. We exhibited before the court, but Sessions Court do not rely, and ultimately the High Court relied. Second thing, there is one eyewitness in our case who said, I saw this guy in the local train. वो बैग लेके चढ़ा, बैग रैक पे रखा, and without taking back the bag, he left the train. And after some time, bomb exploded. तो उसको पूछा गया, why you are traveling in that particular train on those days? He said, I wanted to meet my friend in ENT hospital in Mumbai. I wanted to go and meet another friend in some bank. So we filed the application in ENT hospital. And we asked whether this particular name person is a worker of in ENT hospital, whether he was present on the said day in the ENT hospital. The reply was surprising. The reply says that no such person is working in ENT hospital. In similar application we filed in the bank, and they said there is no person in that bank working. A person of that name working in the bank, but he was absent. He was absent on particular date, on the said date. So we exhibited the RTA applications information, but the Sessions Court did not rely, and luckily the High Court relied and said the eyewitness is not an eyewitness but a police witness, a tutored witness. Next is, when we talk about the right to fair trial, whenever we file application, right to information, the ATS try their level best not to reach those applications to particular authority. They write the letters to the particular authority not to supply any information to this accused person. इनको कोई इंफॉर्मेशन मत दो, ऐसा ATS वाले जो है लिखते थे. And one interesting thing and very surprising, there are 6 original eyewitnesses in this case. 6 original who saw the suspect while they were traveling in the train. And when the bomb blast took place, those eyewitnesses injured. And very next day they approached the police. They recorded their statements. With the help of their statements, police prepared 2 sketches. They described the suspects in detail. And with the help of their statements, I said two sketches were prepared, and surprisingly, ATS never called those witnesses in the court for deposition, for giving the evidence, never called. And after the blast, after 100 days of blast, police prepared some eyewitnesses. And after 100 days, those fake eyewitnesses recorded their statements. They came to the jail for the TIP, test identification parade, and after the blast, 4.5 years, they came in the jail, in the court for the deposition. So this is the first strange case. आई विटनेस है ओरिजिनल, पुलिस नहीं बुलाना चाहती, और 6 आई विटनेसेस, नकली आई विटनेसेस को खड़ा किया जाता है आफ्टर 100 डेज, और उनको जो है कोर्ट में बुलाया जाता है गवाही के लिए. This is the tendency of police to plant RDX on Muslim youths. This is not the first case. I will mention you so many cases how police planted RDX arms and ammunitions on the Muslim accused persons. In this case, police planted RDX and detonators on 5 accused persons. And the name of police is ACP, Assistant Commissioner of Police Kishan Shingal. He himself, with the help of entire police force, he planted RDX on 5 accused persons. And this is the same guy, this is the same officer who planted the RDX after this case in Malegaon bomb blast case. You know, in Malegaon bomb blast, Shab-e Barat, Kabristan bomb blast case, you have remember in 2006, 9 Muslim youths were arrested. और ये the same person, शेंगाल, उसमें भी RDX को plant करता है. After our case in 2010, German bakery bomb blast case, you have heard. In German bakery bomb blast case, Himayat Mirza Beg, a person from Udgir, arrested, and in the same case, police ATS planted the RDX on him. Earlier to this case, in 2004, I guess in 2004, Akshardham Mandir attack case in Gujarat, Mufti Abdul Qayyum and some other persons were arrested in that attack, and the police department planted RDX and arms and ammunition on those guys. Later on, all those persons in Akshardham attack case released by the Supreme Court. In fact, they were given death penalty by the Sessions Court. And after releasing, he has written a book titled 11th Years Behind the Bar, 11 साल सलाखों के पीछे, written by Mufti Abdul Qayyum. So I said you कि किस तरह पुलिस वाले RDX को जो है मुस्लिम नौजवानों पे प्लांट करते हैं, और किस तरह से how they implicate in terror cases. One more interesting thing. In criminal cases, particularly in terror cases, and more particularly in MCOC cases, you know the MCOC, Maharashtra Control of Organized Crime Syndicate. It's a special law in Maharashtra, which is applicable in Maharashtra as well as in Delhi. In that case, whenever a person arrested under MCOC Act, Makoka Act, their call data record is very important. And it's produced before the court for the establishment of his guilt, establishment of his crime, establishment of his location on the date of crime. But in our case, ATS destroyed all the call data records of our phones. They said, we are not relying on your call data record. We are not relying on the call data record locations. What is the allegation of ATS? The main allegation is on 11th July 2006, you are in Churchgate station, Churchgate, a railway station in Mumbai. or you were planting a bomb in a train. And what is our defense? कि हम 11 जुलाई को चर्च गेट में नहीं थे, हमारा फोन का सीडीआर देख लो, लेट्स चेक आवर सीडीआर लोकेशन. वो क्या कह रहे हैं? वी डू नॉट रिलाई योर सीडीआर लोकेशन, डिस्ट्रॉय. और फिर बाद में बॉम्बे हाई कोर्ट में पिटीशन फाइल करना पड़ा. और जस्टिस अभय टिपसे, आपने नाम सुना होगा, जब जस्टिस अभय टिपसे पास्ड ऑर्डर टू प्रोवाइड द सीडीआर ऑफ ईच एंड एवरी एक्यूज. और सीडीआर का प्रॉब्लम यह है कि 2 साल के बाद आपको नहीं मिल सकता. लीगली आपको 1 साल में मिलता है, कोर्ट के ऑर्डर से 2 साल में मिलता है, उसके बाद नहीं मिलता है. वो सब जो है अपने आप खत्म हो जाता है, रिट्रीव करना पड़ता है, जिसके लिए बहुत पैसे की जरूरत पड़ती है, बहुत मेहनत की जरूरत पड़ती है. फिर ये हुआ कि बॉम्बे हाई कोर्ट के ऑर्डर से वो सीडीआर आया. आरटीआई, वी हैड फाइल्ड आरटीआई फॉर ऑब्टेनिंग द सीडीआर टू द telephone companies, and we received those RTI CDR data, and we produced it before the High Court. One main allegation is these accused persons were in contact and regular touch with the Pakistans, with the Azam Chima of Lashkar-e-Taiba, these and that. And when we are in touch with Pakistan, where is the CDR? Where is the call data record? Where is the proof? No proof as such. और ATS ने जानबूझ के इसको डिस्ट्रॉय किया, क्योंकि उनका ये एलिगेशन जो है उसमें साबित नहीं हो रहा था. कॉन्स्पिरेसी जो बताई गई है, वीक कॉन्स्पिरेसी. कुछ लोग पाकिस्तान से आए. How they came to Mumbai? Kamal Ansari is a accused person in this case. He was from Basupatti, Bihar. वो बॉम्बे आया और उसने पाकिस्तानियों के साथ बॉम्ब को प्लान किया. How it is possible for a strange person to come in a new city and manage everything easily? High Court raised the question. How it is possible? Nothing clarification given by the ATS. One allegation is one accused person instructed another accused persons to bring some chemicals. The Bombay High Court raised the question, what are those chemicals? Those chemicals are easily available in market. Those chemicals are not hazardous. So why he instructed another accused to bring those, and the another accused brought those chemicals and put his locker for long 1 year? What is the reason for putting these chemicals in the locker? 1 साल तक के वो लॉकर में क्यों रखेगा? The Bombay High Court raised the question. One more allegation is bomb making process was going on in Govandi, in a house of मोहम्मद अली. उसका घर बहुत छोटा है. It was very small house. The Bombay High Court raised the question. There are so many houses of accused persons, big flats. वहां पे नहीं हो रहा है बॉम्ब मेकिंग, इसके घर पे हो रहा है. Why? ओपन है, dense populated, Muslim populated area है गोवंडी, शिवाजी नगर. तो why the accused person choose those particular house for making the bomb? No clarification, no reason. One more allegation, मेरे घर में सब पाकिस्तानी आया, मैंने शेल्टर दिया, और वो पाकिस्तानी they went very safely back to the Pakistan. High Court raised the question, how it is possible? And more interestingly, why these Indian guys stay here? पाकिस्तानियों के साथ भाग क्यों नहीं गए? ये क्यों यहां पे रुके? ये 13 हिंदुस्तानी रुके थे, और जो लोग आए 6-7 पाकिस्तानी वो चले गए. जब वो चले गए तो इनके साथ ये भी जा सकते थे. इतना बड़ा ब्लास्ट किया है तो ये इनको कोई डर नहीं है. And per contra, they are living in the society, in city, and whenever police contacted him, whenever police called him, they all accused person visited the police stations. Sometimes police interrogate them, sometimes police kept them in illegal detention, sometimes police released them, sometimes police recorded their statements. For 3 months, myself and other accused persons were in contact and regular touch with the Bombay police. So Bombay High Court raised the question, why they are here? If they are guilty person, if they had committed the bomb blast, why they are in regular touch with the police department? One more thing, ये कहा गया कि प्रेशर कुकर के अंदर बॉम्ब रखा गया. आपने सुना होगा प्रेशर कुकर थियरी, but there is no mention in any confessional statements by the accused persons that they used pressure cooker for packing the bomb. In confessional statements, they use the word household utensils. घर में इस्तेमाल होने वाला बर्तन, कोई बर्तन है घर का, उसमें बॉम्ब रखा, but there is no mentioning of pressure cooker. तो ये प्रेशर कुकर कहां से आया? ये किसने क्रिएट किया? क्या साइज था? What was the size of pressure cookers? What was the make of pressure cooker? Which company? How they brought it? From where they brought it? Nothing is clear. And it's very surprising कि बॉम्ब ब्लास्ट का ट्रिगरिंग डिवाइस क्या था? ये जो है रिमोट कंट्रोल था, ये जो है रिमोट कंट्रोल था, या ये जो है डायरेक्ट टाइमर था? नॉट मेंशन, नॉट क्लियर. जितनी बात पुलिस को मालूम है, द सेम थिंग्स आर इन द नॉलेज ऑफ एक्यूज्ड पर्सन्स. When they went for the confessional statement, recording of confessional statement, not a single word added by the accused person. Whatever knows to the police department, those all things are in the confessional statements, not apart from that. एक भी लाइन नहीं. तो आप 3 महीने तक यू आर गोइंग इन्वेस्टिगेशन, लाखों रुपया आपने खर्च किया है, और एट द एंड व्हाट इज द रिजल्ट? You even do not know how the bomb exploded, whether it is with the help of triggering devices, whether it is with the help of timer, और जो है सेकंड चीज, किससे आपने जो है बॉम्ब ब्लास्ट किया ये मालूम नहीं है. रिमोट कंट्रोल. There is no clarification of Mahim and Bandra planter. 2 bombs were exploded one in Mahim station and another in Bandra station. So who planted those bombs? It is not clear. One more thing, Al-Qaeda manual. As I said, whenever we make any complaint before the judge of torture, of ill treatment by the police department, what the counter by the prosecution? The counter is, sir, they are following the Al-Qaeda manual. The Al-Qaeda manual teaches them how to misguide the investigation agency, how to misguide the judiciary, how to put the allegations, heavy allegations on the investigation department. They are following the Al-Qaeda manual. We said, sir, they are torturing us. They are not giving us food, and they are forcefully taking our signature on the confessional statements. और वो क्या जवाब होते थे? Sir, this is all wrong. They are following the Al-Qaeda. In Bombay High Court, Sessions Court relied, okay, they are following Al-Qaeda manual, they convicted. Bombay High Court is not under the pressure of government. These two judges, Justice Anil Khilor and Justice Chandak, what they raise the question, where is the Al-Qaeda manual? You are time and again the ATS and the police saying they are following the Al-Qaeda manual. Where is the Al-Qaeda manual? Bring it before the court. If you have any Al-Qaeda manual, so show us. We will examine. We will see what is the content, who prepared it, how it was published, who is the author of Al Qaeda manual. Nothing is, nothing, there is nothing on record. Out of 13 accused, 11 confessional statements were recorded by the DCPs of Mumbai police. And all the confessional statements are identical. Copy, cut, paste. The same questions and answers are recorded by one DCP of one accused. Same questions and answers are recorded by another DCP for another accused person. When you see the 11 confessional statements, you will find the similarity. Questions and answers are same. Sequence are same. Except the name of the accused person, the name of the DCP. So Bombay High Court raises the questions, how it is possible? 11 कन्फेशनल स्टेटमेंट अलग अलग जगह रिकॉर्ड हो रहे हैं, अलग अलग दिन रिकॉर्ड हो रहे हैं, रिकॉर्डिंग बाय द अलग अलग डिफरेंट DCPs. Why this similarity? And there are some eclipses. Eclipses of after finishing one incomplete question, we put some dots. It's called eclipses. In 4 confessional statements, the eclipses are same. मच्छर मरा है तो उधर भी मच्छर है. आपको मालूम है कॉपी पेस्ट करने में ये होता है कि जो कॉपी करता है तो मच्छर मरा हुआ रहता है तो वहां भी मच्छर बनाता है वो. तो in this case, in this confessional statements, eclipses एक जगह था, कॉपी पेस्ट करने में सब जगह eclipses आ गया, 4 डॉट्स सब जगह आपको 4. So in such a way, confessional statements were prepared by the ATS, supplied by the ATS to the DCPs, and only accused persons were asked to put their signature by hook or by crook. Otherwise, you will face the torture. उसके बाद आप देखेंगे कि जो कन्फेशनल स्टेटमेंट्स है उसको कबूल करके सजा दी गई. टॉर्चर. 655 pages of Bombay High Court judgments, 100 pages are on torture. 100 pages discussed on torture. 241 paragraphs are discussed for the torture. How these accused persons were tortured, why they were tortured, what was the method used for torturing these accused persons, what was the result of the torture. 100 pages. मैं कानून का स्टूडेंट्स हूँ. I have heard and I have read many high courts and Supreme Court judgments. I read the very famous landmark judgment you have heard, D.K. Basu versus West Bengal. लेकिन मैंने इतना बड़ा टॉर्चर के बारे में जजमेंट में कभी नहीं देखा. This is the first time in Indian judiciary system in which divisional bench of Bombay High Court mentioned and talked about the torture on 100 pages. And it is established that these guys, these accused persons were brutally tortured with the hands of the ATS for the recording of confessional statement, for putting their signature on ready-made confessional statements. Once they put their signature on confessional statements, police stopped for torturing the accused person. The main purpose, the main motto of the police is to extract the confessional statement, in fact to take the signature of the accused person. So guys, dear friends, this is the story of Bombay High Court's judgments. I suggest you again, once more, please go through the judgment, please read the judgment. It's a brilliant judgment. It's very beautifully drafted judgment by the Divisional Bombay High Court. And for the first time, This judgment recognized that the Mumbai police fabricated evidence on Muslim youths. For the first time, it recognized that the Muslim youths were falsely arrested in a bomb blast case. For the first time, it says that the Muslim youths were brutally tortured by the ATS police. And for the first time, it says that on the basis of fake evidence, Sessions Court committed grave error for convicting those accused persons. For the first time, it says, it recognizes that the Indian Muslims are not terrorists, but they are terrorized at the hand of terrorist squad that is called ATS. Assalamu alaikum. Khuda Hafiz.